Imagine walking down the street, minding your own business, when a massive, speeding vehicle suddenly runs you over. The driver doesn't stop. You end up with shattered bones, a ruined livelihood, and astronomical medical bills. Today, you would call a lawyer and sue the owner for everything they are worth. But what if the vehicle that hit you was an ornate, gold plated royal carriage, and the owner was the King of England? Well, in Georgian England, you wouldn't get a massive settlement or a day in court. Instead, you would smash headfirst into a legal brick wall so absurdly absolute that it protected the monarchy from traffic accidents for centuries. Welcome to Exhibit Absurd. Our story takes us to the bustling, grimy streets of Georgian England. This was an era before traffic lights, speed limits, or basic right-of-way rules existed. Cobblestone roads were packed with pedestrians, street vendors, and livestock. Carriages back then were essentially the heavy, roaring SUVs of the 18th century, hulking wood and iron death traps, traveling at terrifying speeds. But the absolute most dangerous vehicles on the road didn't belong to drunk merchants or reckless farmers. They belonged to the crown. Royal carriages, driven by the king's personal staff, routinely barreled through the narrow alleys of London, demanding everyone clear the path. And naturally, people got run over. When ordinary citizens had their carts smashed to splinters or their legs broken by a royal hit and run, they assumed they could do what any Englishman would do: take the owner to court. They were horribly wrong. When these injured pedestrians tried to file a lawsuit, they slammed face first into an ancient foundational piece of British common law: sovereign immunity. The entire legal system was built on a Latin maxim called rex non potest peccare, which literally translates to "the king can do no wrong." This wasn't just a fancy philosophical metaphor. In the eyes of the law, the monarch was legally incapable of committing a civil wrong, being negligent, or making a mistake. Furthermore, because the courts were technically the king's courts operating under his authority, you legally could not sue the king in his own court system. To even attempt to seek justice, a citizen had to submit a bureaucratic monstrosity called a petition of right. You essentially had to write a polite letter to the king's ministers, begging the monarch for permission to let his courts hear your grievance. For the case to proceed, the king had to manually endorse it with the phrase, "Fiat justitia," let justice be done. For property disputes, the crown occasionally agreed. But for injuries caused by negligence, the answer was a universal, systematic no. In standard employment law, if a commercial delivery driver runs you over, you don't just sue the driver. You sue the wealthy company they work for under a concept called vicarious liability. But the Georgian courts engineered a brilliant, twisted loophole around this. They cited a landmark 1701 case called Lane and Cotton, which involved a postmaster whose employees lost a valuable letter. The court ruled that because the head of a state department is a public servant, they aren't responsible for the negligence of their staff. Applied to the king, the logic became completely unhinged. Because the king is legally perfect and cannot do wrong, he is also legally incapable of authorizing anyone else to do wrong on his behalf. Therefore, if a royal coachman drove recklessly and ran you over, the law declared that the coachman must have been acting entirely on his own frolic. The king was legally wiped from the equation. The crown didn't owe you a single penny for your medical bills. Your only option was to sue the poor, terrified servant holding the reins. So, out of sheer desperation, victims did exactly that. They dragged individual royal coachmen into court, but this was a financial dead end. Even if a judge found the driver completely at fault, these drivers were working-class servants making meager wages. They didn't have the hundreds of pounds needed to pay for broken limbs or destroyed wagons. You could win the moral victory, but there was zero cash to collect. The legal system essentially forced the poorest employees of the state to act as human shields for the monarchy's reckless driving. And to prove just how far the government would take this absurdity, look at the case of Viscount Canterbury and Attorney General in 1843. Royal workmen were told to burn a massive backlog of ancient wooden accounting sticks in the furnaces beneath the House of Parliament. They got reckless, overheated the flues, and accidentally burned down the entire historic British Parliament building. The Speaker of the House lost all his personal furniture in the blaze and tried to sue the government. The courts completely threw the case out, reconfirming that even if state workers burned down the Capitol, the Crown bears zero liability for their negligence. As the centuries rolled on, the government got bigger. By the 1940s, the Crown wasn't just operating a few royal carriages, they were driving thousands of military trucks, operating public railways, and running massive ordnance factories during World War II. People were getting hurt constantly. To avoid total public outrage while still protecting sovereign immunity, the British government invented a hilarious, shady workaround called the nominated defendant system. If a military vehicle hit you, the government would supply the name of a low-level driver. You would sue that specific soldier or mechanic. If you won, the Crown would secretly step in behind closed doors and pay the damages as an ex gratia payment, meaning a voluntary favor, not a legal obligation. It was a complete charade designed to keep the Crown's immunity pristine while quietly paying off the public. But in the late 1940s, the highest court in the land, the House of Lords, finally had enough of this theatrical nonsense. In two landmark cases, Adams and Naylor and Royster and Cavey, the judges flat out refused to play along. They declared they would no longer pretend a random low-level factory worker or army driver was personally liable for massive state-level accidents. They struck down the nominated defendant system completely. This judicial mic drop caused absolute legal chaos. By striking down the workaround, the judges exposed the raw, ugly reality of the law. Overnight, if a government vehicle ran you over, you could no longer use the workaround, and you still couldn't sue the crown. Victims of government negligence were suddenly left with literally zero legal remedy. The public and the powerful trade unions were absolutely furious. Facing a monumental post war political crisis, the government was trapped. In 1947, Parliament was forced to capitulate. They hurriedly drafted and passed the Crown Proceedings Act. For the first time in British history, the ancient maxim was dismantled. Regular citizens could finally sue the government and the monarch's departments for civil wrongs, just like any private business. The era of the unaccountable royal hit and run was officially dead. The long, chaotic history of royal traffic accidents proves that sometimes the law isn't about protecting the innocent. It's just a highly sophisticated framework designed to make sure the guy at the very top never has to pick up the tab. If you want to uncover more bizarre evidence from the most petty, absurd, and chaotic archives of legal history, make sure to hit that like and subscribe button. We'll see you next time on Exhibit Absurd.